Hi, I'm Byron Williams. I'm Director of the Public Interest Law Center, or PILC. PILC is an office of dedicated legal professionals, and we work with the law to advance economic and social equality. Our clients are individuals or groups who want to make changes in the areas of environmental law, human rights, consumer rights, access to justice, and the revitalization and assertion of Indigenous legal orders. Our team has helped put together this webinar series because public engagement with legal processes is a cornerstone of democracy. The ongoing climate change crisis and our shared responsibility towards reconciliation makes this engagement particularly relevant in the area of environmental law. We've invited guest speakers to share their knowledge and to improve public understanding how each of us can do our little bit more to engage in the decision-making process that impacts us all. We're so grateful that you've joined this discussion, and we look forward to hearing your feedback. Thank you.
My name's Glenn Korolick. I'm the Executive Director of the Manitoba Eco Network, and we're one of the sponsors of the Navigating the Law series, along with the Public Interest Law Center. For those who don't know anything about the Manitoba Eco Network, we're a nonprofit, charitable environmental organization. We've been around for about 35 years. The organization is doing some great stuff these days with all the volunteers and our new board of directors, and a good example is this webinar series, which we hope you'll enjoy. If you have any feedback after the session, please provide it to us, and we're always looking to make improvements. Once again, thank you for attending, and I hope you have an enjoyable webinar, and we'll talk to you again.
Bonjour, bonjour. Good afternoon. Welcome to the final installment of the Navigating the Law to Protect the Environment webinar series. I'm Byron Williams, and I'm proud to be your host for today's event. As we begin, it is important to acknowledge that while many of you will be viewing from all over Turtle Island, the organizing team behind this project are working from Treaty 1 territory on the lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene people, and the heartland of the Métis people. We are grateful to be here. We would like to thank the Manitoba Law Foundation, who are providing financial support for this series, as well as the University of Winnipeg, which is providing financial, intellectual, and technical support. Thank you also to Bryce Brennan from the University of Winnipeg Tech team for all his help, and to Ella Arneson of National Captioning Canada, who is providing a closed captioning for this event. You can access the closed captioning by clicking the live transcript button, which is on the bottom toolbar. This webinar is titled Reconciliation and Environmental Law. Clearly, reconciliation is central to Canada's current legal, cultural, and political moment. In the legal world, the implications of this theme have been hotly contested, particularly so with regard to environmental law. In this webinar, our speakers will discuss reconciliation in the context of environmental law and what we need to do to work towards it. For me, it's such a great pleasure to introduce our two guest speakers, Professor Amay Kraft and Meryl Ann Fair. Amay is an award-winning teacher and researcher. She's recognized internationally as a leader in the areas of Indigenous law, treaties, and water. She prioritizes Indigenous-led and interdisciplinary research, including through visual arts and films, and she co-leads a series of major research grants on decolonizing water governance. Amay works with many Indigenous nations and communities on relationships with and responsibilities to water. Aimé is an associate professor at the Faculty of Common Law at the University of Ottawa and an Indigenous lawyer from Treaty 1 in Manitoba. She also happens to be a former lawyer from the Public Interest Law Center. Marilyn Fair is a lawyer, writer, and the founding executive director of the Center for Indigenous Environmental Resources, CIER, a national First Nation charitable environmental organization. Currently, she is a commissioner of the International Joint Commission. Previously, as chief negotiator, Meryl Ann led the negotiation of a very innovative transboundary water agreements, a series of them in the Mackenzie River Basin. She is the author of the book, Denying the Source, The Crisis of First Nation Water Rights, and co-author of Ethical Water. She facilitates the Collaborative Leadership Initiative in Southern Manitoba and is a member of the Forum for Leadership on Water, Smart Prosperity Leadership Council, and a recipient of Canada's Clean 50 Award. During today's webinar, Aimé and Marilyn will each discuss their own perspective on what reconciliation means, what the challenges are in working towards it, and most importantly, potential solutions. We run a tight ship here, so we're expecting to finish the event with a 50-minute question and answer session. If you do have questions throughout the event, please park them in the chat function and they will be asked, or we'll do our best to ask them of our speakers during the question and answer session. To start us off and to mute me, I'll invite Professor Kraft and then Meryl Ann to briefly explain how we should be thinking about reconciliation for the purpose of this discussion. Thank you. Over to you, Aimé.
Thank you, Byron. Bonjour, ndinu magniduk. It's a pleasure to be joining you today for this conversation, and I always appreciate the opportunity to exchange ideas with Marilyn. So I'm quite happy to be part of this today. And thank you again, Byron, for the invitation and the introduction. I'm joining you from Treaty 1 territory. Those of us who are here know we still have some snow out and we're anxiously awaiting spring at this point in time. And I think spring is a great metaphor for thinking about reconciliation and renewal. And that's actually something that was built directly into our treaty making and treaty promises. I recently wrote a children's book and published a children's book that takes up some of these themes and how we learn Indigenous laws from our natural environment and how we think about concepts of renewal and relationship and reciprocity and responsibility as how we model all of our relationships and how we make those relationships work over time. And I think that that's a key to understanding what reconciliation actually is. We're in the spring of a new beginning, new opportunity to reinvigorate relationships, and those relationships that exist not only with the Crown or settlers, with Indigenous people, but also with the land itself. And I think we're at a critical point in time where reconciliation has to take into account our reconciliation with the lands and waters around us as an important part of thinking about and acting on how we journey forward. So to ground the question of reconciliation, I'll just very briefly say that I think there are 2 points of intervention that we should be aware of. The first is how the TRC has reframed reconciliation into the idea or the concept of establishing and maintaining mutually respectful relationships. So again, that's centering around relationships, the mutuality, the idea that these are long-term, sustainable relationships that have to be built up over time. I think secondly, we want to distinguish sort of an old view of thinking about reconciliation and one that's actually supported by Canadian common law. The Supreme Court of Canada refers to reconciliation as a balancing of interests, especially in relation to prior occupation of territories by Indigenous people with concepts of Crown sovereignty. And I think that's an outdated way of looking at reconciliation as a way of justifying the dispossession of land. And I think that that needs to be squarely set aside. So what the TRC told us in terms of maintaining and establishing these mutually respectful relationships was that the United Nations Declaration on the Rights of Indigenous People had to be the framework for reconciliation. And I think that's an important starting point for us in the discussion today in thinking about actions that relate to reconciliation, both to address the legacy of colonialism, including residential schools, but also thinking to the future and thinking about how we reconcile damaged relationships and try and extract ourselves from a colonial Canadian past while at the same time acknowledging it. I think a really important part of that is the recognition of Indigenous laws and legal orders, and I hope to focus some of my comments on that today. But that's what I wanted to say in terms of setting the stage on reconciliation.
Thanks, Amy. I love your metaphor for spring. I haven't heard that before. It's lovely. I think I will start by sharing the opening of a podcast that I do on reconciliation, which is called Porcupine. And it goes, I start by going, how did two porcupines hug? Very carefully. And such is the story of reconciliation, at least so far. And the reason I started that way is because reconciliation is controversial and why I think very wide views about what it actually means. And so I'm going to start with explaining what I've heard it be described as through the dozen or so folks I've interviewed on the podcast. And the first one is Stan McKay, who's an elder from Fisher River Cree Nation. And he calls it basically reconciliation is about creating right relationship, which is very similar to what Amy just said, but he uses those words, right relationship, and he describes it as building and restoring trust and respect, probably more focused on building than restoring because we have had a difficult time so far, but it's also about healing while remembering. And there's a number of different aspects of this that I want to point out that I've pulled from the interviews I've done and all the work I've done over my time, is that reconciliation is a 360-degree responsibility. That's how we look at it. I'm a non-Indigenous person and I'm doing a podcast on reconciliation because I believe that. I interview both Indigenous and non-Indigenous people because everybody has a role in it. It is not something that just Indigenous people have this responsibility to just do, or can they just deal with it already or whatever. And that's one of the driving forces by why I did any of this work, is because there's so many amazing people that are doing things, and we need to kind of each look at our own role in it, in our jobs, in our life. What's our piece of this right relationship? The other thing is reconciliation is in the eye of the beholder. We each have to feel that reconciliation has happened. It's not just on one group of people to, as I said, deal with it. Each of us have to feel that there has been a movement towards this relationship. It's layered. It goes in multiple directions. It's individual, family, communities, government. As Amy said, and I'll spend a bit of time on this in the subsequent comments I make, it is about a global. It's also about our relationship with land and other species. And so it's very multi-directional. And our history of colonization here has created a problem where we have separated Indigenous people from their own people in many places. And so many of the people I work with are going through a process of internal reconciliation first to restore the unity of their nation that was severed by things like the Indian Act and residential schools and things like that. So reconciliation sometimes begins with an internal nation level process or personal process. It is both an outcome and a process, I think. It's a ongoing path with things, and the reason I do say outcome is because things do need to change. We need to be able to see that there's actual changes. So those are outcomes. It's just not one outcome, it's many. Constant evolution and change towards that right relationship. And I think at the end of the day, is, and this is one of the pieces that Stan McKay said to me, is that right relationship has to be about the relationship we have with the earth, not just each other. And so I was talking to him about the idea of a covenant and what the original treaties meant in terms of the agreement that was made. And he said it was about relationships with each other, the creator and land. And so that's an ultimate. So I'll stop there in terms of reconciliation. So now I go on to question number 2, do I not?
You do, and I'm going to just block off my video again.
Okay. Okay. Sorry for that awkward transition. The second question we'd like to talk about is, what are some of the challenges to reconciliation? And I'm going to focus on just 3, and they're going to be mostly focused on governance and environment, because I know that Amy is going to talk quite a bit about Indigenous law and jurisdictions, and I don't want to duplicate. So my main, and I'm going to resist trying to talk about the solutions, because we do have a long, kind of a very interesting, I think, an exciting list of potential solutions to some of these challenges. So I'll keep it high level. First, just a key challenge when you think of reconciliation and environmental law is just the idea of environmental law itself, right? Environmental law is a subset of the law. It's not a foundation. Canada was founded as a shopping cart, basically, for the colonizer. It was just seen as a vast area of resources that could be taken. And so, you know, environmental laws and our legal systems are really embed that in so many ways, from tax law, trade law, our whole idea of economic growth. There's just so many ways that our legal system protects that fundamental shopping cart idea. And environmental law is really just a limit to that, right? It's a no, you can't, no, you can't. And you know how well humans react to being told, no, you can't have something. And so this denial kind of role of environmental law is just, it just needs to be flipped on its head. And it certainly isn't about this right relationship with nature or the earth. And so, you know, from Indigenous, just an overarching concept you've probably all heard is this idea of all our relations. And one of the fundamental things I think environmental law doesn't do and needs to, if we're ever to move towards reconciliation, is embed this concept of all our relations, that we treat it is a fundamental mechanism to treat all aspects of the natural world of which we are a part as a big family, a big set of relationships. So that was number 1. Number 2 is there's just no overarching duty of government to make decisions that are in the best interests of the thing that they ultimately, you know, as a sovereign nation, the country, the land, the waters of Canada are the responsibilities of governments, but there's no actual duty that says we have to act in their best interests. And that's, other countries have that, including the United States. And so it's not impossible, but we don't have that. The final one is a governance barrier. It's just that we have this amnesia in this country about how we operate and how decisions are made, this amnesia of history. And John Burroughs, in this book, if you want to read it, is fantastic, explains it really well, how valid and now integral Indigenous governance traditions, Indigenous many processes and laws and procedures, all of it were integral to how Canada was created and made decisions. Somehow now, though, we forget that. We forget that cooperative federalism in Canada can, must, and did, and needs to continue, needs to include Indigenous people. And it doesn't. We act like if we have a complicated country and it's awkward. We have cooperative federalism because we're big. We have lots of diverse regional interests. We have a charter. We have multicultural commitments. We have lots of stuff that make it hard. And that's why we set up tables and have this cooperative federalist approach. But we act like if Indigenous people are there, it's going to threaten Crown sovereignty. And so that's a huge, huge barrier. But those rooms are the decisions where decisions are made that get us closer to reconciliation or further away from it. So that's why that's critical. Now we'll stop there and turn it over to Amy now.
Thanks, Marilyn. In terms of challenges, I think, yeah, the idea of environmental law, as you said, is challenging in itself. The Supreme Court just ruled on the carbon tax reference, and they said this is of national interest because it's national interest and it meets these tests, and we can legislate under peace, order, and good government. But part of the rationale for that is international commitments. And I think where Crown actors and where Canada is maybe not domestically excelling, we can point to some international instruments to help us understand what obligations are in terms of the environment. And I think that we read them in connection to each other. So I think that's the point that I want to start at, is thinking about this international commitment that Canada has to the Paris Accord, to international standards relating to environmental, reversing or halting environmental degradation. I'm still going to say this is not super positive. We're just trying to do less harm. And also looking at the commitment to the United Nations Declaration on the Rights of Indigenous Peoples that's currently before Parliament in an implementation legislation. So I think those are, two strong elements that help support what we could aspirationally think of in terms of reconciliation and environmental law. I think there's a long way to go yet in terms of the common law. And I think you've started to allude to this, Marilyn, is that this Crown sovereignty that's so precarious and the foundations of Canadian common law in relation to Indigenous people are resting on shaky foundations of terra nullius and doctrine of discovery, which the TRC has said, got to get rid of it. The Supreme Court has tried to say it through the words of former Chief Justice McLaughlin and saying it's never applied in Canada, but in the next paragraph basically relies on it to justify the test for Aboriginal title and the recognition of title and the limiting of Aboriginal title through the Canadian common law. So I think we've got some unraveling to do in the common law. And I think there are three places that we need to move past the current limitations. So I've mentioned terra nullius, doctrine of discovery, as the foundations. I think that needs to be addressed by the common law, and that's not only done through Parliament and legislation, that has to be within the courts as well. And I think that we need to move beyond also the doctrine of consultation and accommodation of Indigenous people's interests that's been established as part of Section 35 of the Constitution. So consultation and accommodation relies on these ideas that the Crown does have sovereignty and that Indigenous interests have to be somehow accommodated by the Crown, and the Crown is still the primary decision maker or actor. And that needs to be turned on its head. I think also a third area of law that we need to seriously think about reforming is environmental assessment and environmental decision making. And looking at the role of Indigenous nations in environmental decision making as leaders, not stakeholders, not parties. And that doesn't mean, I think, what we've seen manifest in the past. We've seen quote unquote progress where Indigenous people have been more involved in environmental decision making, but mostly in terms of providing evidence, supporting environmental assessment, and in many ways validating Western science through Indigenous forms of knowledge. And my bottom line is that that's not enough. That's not even close to enough. That the decisions themselves, the principles by which we decide whether or not projects should go forward or things should be done, or if we need to take action, should be done in accordance with Indigenous legal principles. So that requires not only understanding those principles, engaging with them, rethinking environmental assessment so that it's done from an Indigenous perspective, but it means changing the process before we can even get to the substance. So there's two very important parts of a reform of what might be considered environmental assessment or environmental decision making that requires a rethink of how we make decisions, who makes decisions, and what are the principles by which we make those decisions. And I think globally, we're getting a little bit closer to aligning with Indigenous values in thinking through sustainability frameworks, but still not close enough. And one of the things that's absent from sustainability frameworks is what is so front and center in Indigenous laws and legal orders, which is recognizing, as you said, Marilyn, that all beings are part of creation, that our decision-making should include them, not only as humans making decisions for them, but actually taking them into account and having space for the agency and spiritedness of non-human actors within the decision-making realm. And that's a long and involved conversation that, you know, is happening at a variety of different tables. And I hope we can continue parts of that discussion through the Q&A period. But in terms of, you know, what I think the challenges that we're facing is really a superficial involvement of Indigenous people in accordance with the terms set by the Crown that aims to protect Crown sovereignty at all costs. And we need to rebalance that equation to ensure that Indigenous people are decision makers. If I asked you the question, you know, who would you rather have making decisions about the environment and the future and sustainability of this territory? People that have lived here for thousands of years, that have been observing their natural environment, being in connection with it and acknowledging its own agency and spiritedness? Or would you rather have a government that has existed for roughly 150 years that has capitalist interests at heart? I mean, the answer to that question, I think, seems obvious, but we kind of lose sight of the wealth of ability and decision making that Indigenous people can bring to the table, and we get caught up in equations of power between Crown and Indigenous people that ultimately are harmful to everyone and everything.
Amy, if I could
go ahead.
Sorry, I just wanted to respond to the most fascinating, and I watch really to see what happens with this, but the conversations that are happening in different parts of the world and even in Canada with the Magpie River, this idea of agency, and how do you not just have humans speak on behalf of the river, which is still facing the problem of you'll have a judge who doesn't really get it or know it talking to that person who's representing the river, and how would it change the decision in the end, to actually creating, as you point, space for the agency of these beings to be able to create change. And I'm just fascinated to see how that happens, how it will evolve over time to actually create that change and give that agency rather than just have the human representative there. Don't know if you've seen anything like that anywhere, any progress made in that regard.
I think there are some examples, and I'll point to two. One is, I know some of the conversations that happened in preparation for the Chalk River assessment included having a space for water to have a seat at the table and be sitting and represented, you know, physically there. And I think that that's, you know, some might see it as a gesture, and I think things can be understood at different levels. And I'll use an example of something that I'm doing personally that's not actually part of my research program, but I've undertaken to share water and do a water exchange between Lake Winnipeg and the bodies of water that have legal personhood around the world in India, Aotearoa, New Zealand, and Colombia, and to put those bodies of water into conversation. And I don't know what the result will be. I don't know that I'll ever understand it as a human being, but to think of responsiveness to the idea and to take seriously agency of water, you need to think beyond sort of strict parameters. And that's why I think process is so important, bringing in Indigenous ways of knowing and seeing the world to help us make good decisions. And I think, you know, I'll point to some of the really important work that's been done in environmental assessment and evaluation that has, and Patricia Fitzpatrick is on this call. She's one of the folks that has really educated me in terms of adaptive management and not looking at decisions as sort of set and finalized, but the idea of relationality that's actually built into good and long-term decision making that revisits itself. And those concepts that I was pointing to in terms of treaty making, like renewal and reciprocity, they can actually filter into how decisions get made. And I'm going to say not are made, but get made over time, right? We change the decision with the circumstances. And I think, you know, adaptive management is something that Indigenous people have been doing for thousands of years, right? But it requires relationship and conversation, as we've been pointing out since the beginning of this chat. So Byron, I think we should move on to some of the solutions or opportunities that we see. And one of them that I was starting to, when I said I would give 2 examples, I think I only gave 1. But the second is actually some of the work that's being done by White Earth and the Ojibwe, the tribes, the Chippewa tribes in the States, where they've recognized the rights of Minoman, the rights of wild rice, and the rice having a right to a clean environment, the rice having a right to certain things. And if you look at it, the rights of the rice actually are protecting a whole ecosystem. So but what they've done is place their central relative of the Anishinaabe or the Chippewa people of that region. They've placed their relative at the front and center of their declaration and said, this is our priority, is ensuring the wellness of our relative. Well, in direct consequence, everything will benefit from that. But I think it's a unique approach, because instead of saying, well, what are our interests as humans? What are our rights as humans? And how do we protect the environment as though the environment needed to be protected? It mostly needs to be protected against us or from us. You know, flipping that into how do we respond to the rights that exist for Minoman. And I really like that model and that approach. I think there's a lot to be said also in the current movements around Indigenous protected and conserved areas. So looking at designated uses of land and protection by Indigenous people in accordance with their Indigenous legal orders, as well as the guardian programs that often accompany these protected areas by Indigenous people, right? So being on land, physically on land, doing monitoring and constant evaluation and interacting with people to also educate, and doing basically the things that Indigenous nations have done forever, but doing them in ways that have sort of modern labels on them. I think a lot of that ties to ideas that many of us are currently exploring around land back as a movement. And the other day I was very inspired by a youth who said, you know, to me, land back is back to land. And I thought, okay, I'm gonna unpack this a little bit. What does this mean? And what he was trying to, I think what he was trying to say is physically being back on the land, putting your body on the land, recognizing that your body is land. But I think it also means turning to land and water for our decision making, right? For inspiration about how to have good relationships. And I talked about this book. I'll show you the cover of it. It's really nice art by Luke Swinson. And it's called Treaty Words, for as long as the rivers flow. And what it's saying is, you know, the moral of the story, I guess, would be that we didn't invent how to make good treaties. We didn't invent how to have good relationships. We actually looked at the relationships that exist on land, independent of us as humans, as the inspiration and knowledge for how to build good human relations. So I think that, you know, back to land can mean a lot, and it in some ways, to me, it resonates even more than the catchphrase of land back. Do you have some thoughts on that, Marilyn, or things that you think are appropriate in terms of solutions for getting us closer to reconciliation in environmental law?
Yeah, absolutely. Thank you. I think what I would start with, when responding to your Monoman, I could see people who hear about that having some, I mean, I'm just going to be really frank. People who are not connected to this issue at all could be pretty cynical about how could that change anything, right? But that's the whole point of reconciliation, and why everybody talks about it. Indigenous people and others who are close to it talk about it being about relationship, because when you sit there and learn about wild rice and you learn about its role in the ecosystem and its significance culturally and rights and everything, it changes you. You actually become different when you start to learn through a relationship what someone else's reality is. And so it is a very significant thing to take the time to do that. And that's why I asked, I wonder how about how agency will be given to these parts of the environment, to the ecosystem in front of a judge, because I actually think that legal decision makers are people and they can be persuaded by events that and conversations that move them. And so I will give an example of, so I work with a few other people, Colleen Square and Michael Miltenberger, and we facilitate something called the Collaborative Leadership Initiative. And it really started with that idea that we need to focus on leaders, so municipal mayors and First Nation chiefs. And that was the one slice of reconciliation we chose. First Nations are not equal to municipalities. They have their nations. But we thought, at the most ground level, those are the governments that can affect a lot of change right at the ground level. And so how about if let's talk with them, because I actually think that's an overlooked relationship. So we started a reconciliation process with 26 leaders in Southern Manitoba. And it was a year and a half, almost 2 years of just relationship, just really getting to know each other. And everybody, I think, was, so many times I heard, wow, I had no idea. I didn't know that. And that was both sides. That wasn't just going from one side to the other or one group of people to the other, but it formed the basis of trust, because trust is foundational in relationships. As we think of your own personal relationships, it's the thing that matters to get you through difficult things, miscommunications, misunderstandings, conflict. That's what propels a relationship forward, is to be able to, is if you have trust. And so it built enough trust that these 26 leaders are trying to now work together for 4 years on specific environmental and economic projects. One of them is Lake Winnipeg. They've got some things they're trying to do on that, but it couldn't ever have started or sustained itself if they didn't spend the time to learn about each other and experience some very moving things together. And that's why relationship matters. The other piece is this idea of the assertion of Crown sovereignty. In the Marshall case, it said, rights exist unless they've been extinguished, and there's a really difficult test to prove that. They've been somehow signed away or addressed or what have you through treaty, or they're just incompatible with Crown sovereignty. And that little bit, those few little words are the most problematic words, because it seems like when you get into the rooms of justice departments or bureaucracies in the Crown governments, it's really about, it just seems incompatible with Crown sovereignty. There's no way we can adapt our system. This is the way it works. This is the way it is. You build laws this way. You have federal, provincial, territorial tables. You do not have Indigenous people sitting at those tables permanently, even though they are governments. No, laws can only be built in this one way. Things like that. And it's at those specific moments that you actually have becomes really clear how vague this reconciling sovereignty actually is and how problematic it is. So that's one of the challenges, but a solution is to just sidestep that as leaders and build your own kind of table. And that's what the Collaborative Leadership Initiative tried to do. That's what I know some of my folks up in NWT, Northwest Territories, are trying to do. They're building a Northwest Territories Council of Leaders, which is all of the federal, all of the territorial and Indigenous leaders just trying to come together into a just dialogue table to bring their jurisdictions to the table and just start to talk about what they're going to work on together instead of fighting about jurisdictions. They all know they have some. We don't, the edges are gray in some situations, but if we're all at the same table, we can start to talk about what do we need to do and figure out what to do. And that's actually the just do it approach to building reconciliation. And so that's a key one. And then I think the last one I'll just point out, because I had a few, but I won't get into them, is that just on the ecological, there's this branch of law now being developed called the ecological law. It's pretty amazing. There's some amazing stuff. If you want to read a great book, there's this book, which is Ecological Law and the Planetary Crisis by Jeff Garber. It just came out. And he has developed an 11-point kind of sort of framework for the kind of law we would need that would be basically moral. And by moral, I mean, and others have, I've got a good quote from an author that I use, a female author who writes science fiction, Ursula Le Guin, and she says a moral choice in its basic terms appears to be a choice that favors survival, a choice made in favor of life. Our system needs to be moral in that sense, our legal system. And there's this, he's got an 11-point structure that I think would be an interesting basis of the beginning of a conversation with Indigenous people about environmental law or ecological law that could be supportive of their worldview, life-sustaining parts of our worldview, and could be part of a reconciliation conversation. It includes things like ecological limits must have primacy over economic, political, and other considerations in law. Ecological law is not a subspecialty. It's actually, it permeates the entire legal regime in a systemic, integrated way. Ecological law should focus on reducing the throughput of material and energy in the human economy. Imagine these things showing up in environmental assessment law, or how we approve chemicals in this country, or how we assess what is a significant impact. There's a whole list of them, and I won't use up any more time on that, but I urge you to look at that because it's really interesting food for thought in terms of creating a form of environmental or ecological law that is actually life-sustaining, rather than just trying to very weakly put the brakes on this inexorable move to further destruction, it seems to be. So I will stop with there. Thank you.
I think you've said something that is, aligns with the crux of what we're both talking about, which is, the jurisdictional issue. Like, we could spend the next 150 years talking about jurisdiction and arguing about jurisdiction, but understanding mutual jurisdictions that are working towards a common goal is a pretty significant way of thinking about reconciliation and environmental law. If we had to sum up, I think what we're both saying, that's probably it. And maybe Heather, you were actually just going to say that.
Well, and if I could just say one quick thing too, I know that a lot of the things, at least that I work on or that I talk about, and Amy, you must feel this also sometimes, are met with this, oh, that's completely unrealistic. Like that, I get that a lot, particularly on environmental things, or having Indigenous people sit at the table. It can't be done. And I take that as a huge compliment when people say that, because I know that you never achieve anything bold if you don't ever think anything bold, or if you don't ever really try to change. How can things stay the same and change? They have to change. And so that means change. And that means sometimes really significant change. And I remember being on a bus with a lawyer in BC, I don't know, maybe 10 years ago or 15 years ago, and we were having a conversation about whether we thought there would ever be an Aboriginal title case in Canada that would actually be resolved in the favor of Indigenous people. And I am ashamed to say that at that time I said, I can't see it. I can't see the Crown. I can't see anybody ever seeing that as being compatible with Canada existing. And yet, lo and behold, it happened. And it's going to happen more, and it's going to be negotiated more. And so, you know, we can do these big changes. We actually can. We just have to push them and just do it, is what so I'm constantly about trying to figure out, how can we just do this without having to go all the way to the Supreme Court or get somebody to approve it? How can we demonstrate that it's possible? So I will add that comment.
Thanks so much for all of your very wise and insightful comments. I know I've learned a lot, and I have way too many questions to possibly get to today. So I think I'm just going to start with the next steps. So for all of us here listening to everything that you've told us today and given us all these wonderful information, what would you like to see everyone who's here today do next? What is one thing you'd want us to do after this webinar ends? I know for sure I could recommend some podcasts and books that people should go take a look at. But yeah, I think next steps is an important thing to address.
Well, I know, I'll just start then, because I know what I say to everybody on the reconciliation issue, and my whole mission in it is just to have people think about their role in it. That's all. It's a big question. It's a 360-degree, 32 million kind of number of questions, right? However many people in Canada, we all have a role. What's yours? And to start researching and learning about that, figure out your small piece or big piece of that. And I can suggest it would probably involve reaching out to Indigenous people in some way if you don't already. But for sure, just try to figure out the answer to that question for yourself.
Great question. I'm going to say two things. One is I'm going to shamelessly plug series of videos that I did in collaboration with the David Suzuki Foundation on land back that kind of explores past, present, and future, and sets the stage for some dialogue around reconciliation and thinking through different ways of considering the land back movement. So that is information you can find on the David Suzuki Foundation website. But I'm going to say for individuals that are sitting here, I think I would say my first concrete step is back to land, understanding the relationship with the land that you're from or that you live on. What are the Indigenous names of the territory? What are the treaty relationships that exist? And understanding not sort of just the written version of a treaty, but understanding the depth of a treaty relationship. Finding out how you can be an ally, because I think a lot of times, and Marilyn, you've pointed to this, educating yourself is really important. Connecting with Indigenous people is important, but when you connect with Indigenous people for the purposes of educating you, it continues an exploitative relationship, right? And then you're expecting Indigenous people to do the heavy lifting. So there has to be some self-guided study, and there has to be a willingness to contribute rather than to take. And those are really important things that we can learn in terms of fostering relationships. So where can I be an ally? How can I be a good ally? And there are a lot of toolkits and information that are available online as resources for that.
Thank you. Did you want to add something, Marilyn?
Yeah, I just wanted to give an example too of when you think of maybe in your professional career, your personal life is one thing, whether you want to focus on it there, but in terms of your career, I think every career has every job has a way to look at their world through a different lens. And I'm going to give you one example, which is, people probably have heard of it by now, but when I first started talking about it years ago, it was less well known. And this is this idea of co-drafting legislation. And Indigenous nations are very interested in exercising and implementing their Indigenous laws. And that is what, and so this is a separate issue from that. This is the issue of just, if there's a Crown law, how do we make that better so that it doesn't impact you? And that can be laws that on this face appear to have nothing to do with Indigenous people, like the Canada Health Act or the Canada Water Act or whatever, right? The issue is just, why are Indigenous people not involved in making the laws that run this country? And then you would get into a question of, well, so how did those laws work with Indigenous laws? And that's an issue that Elder Fred Kelly is spending all his time on, which is, harmonization or conflict of laws, or how do these things work together? But I just wanted to share with you that, at least in terms of true co-drafting of laws, where you sit around the table and write a law together, that came out of the Northwest Territories. And it was a minister there who just decided, we're going to do it that way. And the Justice Department went nuts and went like, you can't. We do not, laws are ours. We do not build them together. We go and talk to people after we've done it through first, second, and third reading, and that's the way that laws are built. And he just said, well, then we're going to change that. Like, we're going to do it as, we're going to build it together, and it can still go through first, second, and third reading at some point, but we're going to build it with all hands on the pen, involving Indigenous governments together, sitting there with their lawyers, all of us. And, the resistance of the system, he got through it, but it was major resistance. And that was bumping up against just the way things are. But what it shows is, you can look at what you do from a different angle and say, well, is it really? Why can't we change this? Why couldn't we do it a little bit differently? Where are those rules ground in stone? And take that on, take that system on, and try to change it in some way, And so I wanted to show, because that's as lawyers or as people involved in the law, you'll know how sacred lawmaking, the process is. And yet there's a way to do that differently also. Just about everything should be that way. So let's stop there.
Yeah, and I think in support of that, Marilyn, I would say that in terms of accountability, there are things that guide us in that accountability. I think that every person that's on this call should be reading through UNDRIP and trying to think, what does this mean? How would my world change? How can I do things differently to reflect the values and principles that are there? How can I push for change in terms of recognition of UNDRIP at a provincial, federal, and also municipal level? How can I myself engage in relationships that follow the concepts and principles and rights that are accounted for in the Declaration? And I think marrying that, with the TRC calls to action, the 94 calls to action, and being part of monitoring their implementation, but thinking also of individuals and collective roles. And like you've alluded to in your personal capacity, but in your professional capacity as well, but also as a change maker that kind of maybe straddles your personal and professional spheres. How do you influence policy change and do it in an informed way? There are some very solid tools that are in those calls to action and in UNDRIP that can feed into those discussions about how we then find ways to come to the table together and do things differently, and maybe break some of those old conventions, like how legislation has been made in the past.
Thanks so much. I don't think we're going to have time for another question, so I think it's back to Byron now.
Before I have a little summing up, but with 1 minute each, May or Meryl Ann, is there anything else you'd like to add?
I just want to express my gratitude and thank you for the discussion. I know it could continue for a long time, and I hope that it does. I hope there'll be more opportunities for us to gather and have these conversations and include more people in that discussion.
Meryl Ann?
Just again, also thank you, and I'm prepared to try to answer some of the questions that we did not get to. If there's a way to get a hold of people, or Byron, if your folks want to, you and Eco Network want to facilitate that, because I know we didn't get to any of the questions, but they're really good questions. So
Let's canvas that, and I think that's a very generous offer that we're very grateful for. I just wanted to thank, on behalf of our partner, obviously the Eco Network, as well as the Public Interest Law Center, and our collaborators at the University of Winnipeg. This was amazing. I think I've got 12 takeaways, which is a record for me in a webinar. So I definitely want to thank both UMA and you, Meryl Ann. We do also want to thank our audience. This is our last webinar of the Navigating the Law series. We express our appreciation, obviously, to the Manitoba Law Foundation, the University of Winnipeg, both for providing the necessary support to make this series possible. I'll remind everyone that the webinars have been recorded and they're hosted on the Manitoba Eco Network's webpage. And if you go there, you can also find supporting educational documents for each installment that were developed by Professor Heather Fast. And I think she's got a good reading list coming out of this event as well. Thanks again to our presenters, but also those of you who've joined us today and throughout the webinar series. We hope you've enjoyed it as much as we have, and that you'll be able to go back and make some use of the material we've developed as you see fit. And finally, we just want to wish everyone that you'll stay safe in these tumultuous times, and take care. And with that, we'll close the last episode of our webinar series. Thank you.